5 seconds to go. Start. The combined reading of the aforesaid provisions suggests that there has to be a continuing unlawful activity carried out by an organized crime syndicate, for which more than one charge sheets have been filed before a competent court within the preceding period of 10 years, and that the court has taken cognizance of such offence. Stop. Para. The Supreme Court, in the case of Shivaji Supra, while considering the peri-material provisions of Section 2D of the Maharashtra Control of Organized Crime Act, 1999, to that of Section 2C of the Gujarat Act, which defines continuing unlawful activity, has held thus, para. The significant feature of the two cases is that for crimes number 37 of 2001 and 38 of 2001, the respondents were separately tried and acquitted on 18th January, 2008 in the case of Shiva, and on 28th February, 2006 in the case of Mahmood Khan Pathan. Stop. In the said charge sheets, the respondents were accused of committing offences only under the IPC and the Arms Act. Stop. For the offences punishable under MACOCA, separate and independent charge sheets were filed against the accused persons, in which they were convicted by the trial court, which conviction was reversed by the High Court as noticed earlier. Stop. It was in the above backdrop that the High Court held that once the respondents had been acquitted for the offence punishable under the IPC and Arms Act in crimes number 37 and 38 of 2001, and once the trial court had recorded an acquittal even for the offence punishable under Section 4, read with Section 25 of the Arms Act in MACOCA, crimes number 1 and 2 of 2002, all that remained incriminating was the filing of charge sheets against the respondents in the past and taking of cognizance by the competent court over a period of 10 years prior to the enforcement of the MACOCA. Stop. The filing of charge sheets or taking of the cognizance in the same did not, declared the High Court, by itself constitute an offence punishable under Section 3 of the MACOCA. Stop. That is, because the involvement of respondents in previous offences was just about one requirement, but by no means the only requirement which the prosecution has to satisfy to secure a conviction under MACOCA. Stop. What was equally, if not, more important was the commission of an offence by the respondents that would constitute continuing unlawful activity. Stop. So long as that requirement failed, as was the position in the instant case, there was no question of convicting the respondents under Section 3 of the MACOCA. Stop. That reasoning does not, in our opinion, suffer from any infirmity. Stop. Para. The very fact that more than one charge sheets had been filed against the respondents alleging offences punishable with more than 3 years imprisonment is not enough. Stop. As rightly pointed out by the High Court, commission of offences prior to the enactment of MACOCA does not by itself constitute an offence under MACOCA. Stop.